Trump's military deportation plan, a legal and strategic analysis. In an audacious shift from established norm, President elect Donald Trump has proposed using the US military to assist in the mass deportation of undocumented migrants. This strategy, which includes constructing detention facilities and deploying troops and support rules, has sparked significant debate. Legal experts suggest that while the plan might breach traditional boundaries of governance, it could withstand judicial scrutiny due to legal ambiguities and existing precedents. Trump's advisors have outlined a vision where military personnel would facilitate the logistics of deportation efforts, such as constructing detention camps and transporting individuals slated for removal. This would ostensibly allow immigration officers to focus on investigative and enforcement activities. Trump himself hinted at these measures in a post on Truth Social, affirming claims of his administration's intent to leverage military assets of what could become the most extensive deportation operation in the US history. Historically, presidents have utilized National Guard or active duty military forces at the border for auxiliary tasks such as surveillance and maintenance, raising questions about how far Trump's plan deviates from precedent. The cornerstone of the legal debate is the 1878 Pos Comitatus Act, which restricts federal military involvement in domestic law enforcement. However, exceptions exist. For instance, the Insurrection Act enables military involvement during severe breakdowns of law and order to threats to civil rights. Similarly, support rules such as those envisioned under Trump's plan, surveillance, logistic, and detention infrastructure have historically been permissible. Legal scholars, including Ryan Burke of the U.S. Air Force Academy, argue that the ambiguities in these laws could shield the administration from successful legal challenges. However, the extent of military involvement could open the door for lawsuit, particularly if governors oppose resources allocation or perceive an overreach in federal authority. Michael Paradis, a former Department of Defense attorney, noted that diverting funds to build a detention camp might provoke state-led legal action. Meanwhile, Laura Dickinson of George Washington University highlighted that while invoking the Insurrection Act of mass deportation would challenge constitutional norms, courts are likely to defer to the precedent in matters framed at national security. The National Guard's deployment in domestic crises such as the 2020 George Floyd protests and earlier instances of border reinforcement under Presidents Clinton and George W. Bush offers a glimpse into how Trump's plan might be operationalized. However, significant resistance could emerge if state governors refuse to deploy their National Guard units. In such cases, Trump could unilaterally invoke the Insurrection Act as previous presidents have done, albeit under vastly different circumstances. In such cases, Trump could unilaterally invoke the Insurrection Act as previous presidents have done, albeit under vastly different circumstances such as riots of civil rights crisis. Governors like California's Rob Bonta have already signaled strong opposition to such measures, emphasizing potential challenges to state sovereignty. This resistance underscores the plan politically violently. To meet Trump's ambitious deportations target, detention infrastructure would need an exponential expansion. The American Immigration Council estimates that achieving the proposed scale of 1 million deportation annually would require a 20-fold increase in detention capacity. Stephen Miller, a key immigration advisor, has floated the idea of military-constructed camp which, while legally contentious, could sidestep civilian bureaucratic constraints.